If you are a green card holder in the United States, or if you have a family member who is, then what we are about to share with you today may be one of the most significant pieces of immigration news you have come across in quite some time. Right now, at the highest court in this country, a case is unfolding that could potentially reshape the rights of nearly 13 million lawful permanent residents across America. Whether you have held your green card for 2 years or 20 years, whether you travel abroad regularly for work or family obligations, or whether you simply want to understand how immigration enforcement in this country could shift in the months ahead, you need to stay right here. By the end of this video, you're going to understand what is happening, what it could mean for people like you and your loved ones, and what practical steps you can take right now to protect yourself. Welcome back to US Updates Hub. We are glad you are here. Let us get started with the background, because context matters greatly when it comes to immigration law. In the United States, there is a category of immigration status that sits above a visa but just below full citizenship. That category is called lawful permanent residency, or what most of us simply refer to as a green card. As of early 2024, there were nearly 13 million lawful permanent residents living in the United States, and as the name suggests, green card holders are legally authorized to live and work in this country on an indefinite basis. They build businesses here. They raise families here. They pay taxes, contribute to their communities, and in many cases have called America home for decades. One of the defining features of holding a green card, and one of the things that makes it so valuable, is the presumption that you belong here. That when you travel abroad for a family event, for a medical situation, for a business trip, and then return home to the United States, you are treated as exactly what you are, a returning resident, someone coming home. That presumption, however, is now at the center of a major legal battle before the United States Supreme Court. The case is known as Buarfa versus Mayorkas, and the Supreme Court is considering whether immigration officials may place a returning green card holder on what is called the inadmissibility track, which is essentially a pathway toward removal without already having clear and convincing evidence at the time of reentry that the individual committed a disqualifying offense. The justices heard oral arguments in April 2026, and a decision is expected later this summer. Let that settle for a moment. This is not a theoretical debate taking place in a law school classroom. This is a live case, argued just recently, and the ruling could affect millions of real people across this country. So who is at the center of this case, and why does this situation matter to you? The individual in question is a lawful permanent resident who obtained his green card years ago. At a certain point, he faced criminal charges, and shortly after, he briefly left the United States and returned. Now here is where the story takes a crucial turn, and where the legal question that is now before the Supreme Court truly begins. Typically, when lawful permanent residents return to the United States after a short international trip, they are granted admission, meaning they are free to enter the country and continue living here. But that is not what happened in this case. Instead of being admitted as a returning resident, immigration officials placed him on what is called parole for deferred inspection. Now, the word parole in immigration law does not carry the same meaning it does in criminal law. It has nothing to do with being released from prison. Immigration parole is a legal category that places someone in a kind of legal gray area. They are technically inside the United States, but they are not formally admitted. And that distinction carries enormous consequences. Why does that distinction matter so much? Because under federal immigration law, the standard of proof and the type of proceedings you face differ significantly depending on whether you are treated as someone who has already been admitted to the country or someone who is seeking admission. If a green card holder is treated as seeking admission rather than as a returning resident, they can face what are called inadmissibility proceedings. These are generally more difficult to defend against and carry broader consequences than the standard removal proceedings that would apply to someone who has already been formally admitted. A ruling against the individual in this case could potentially shift the balance of legal protections, giving the government broader authority to place green card holders into a more challenging legal track based on unproven allegations. Now let us talk about what the two sides of this argument are presenting, because it is important to understand both perspectives fairly and clearly. The government's position, argued before the Supreme Court, is essentially this. Border officers should not be required to have clear and convincing evidence of wrongdoing at the exact moment a person arrives at the border. The government argues that burdens of proof and evidentiary standards are concepts that apply in formal adversarial proceedings before a judge, not during the initial border encounter. In other words, the government is suggesting that immigration officers at the border cannot reasonably be expected to conduct a full legal analysis on the spot, and that they should be permitted to gather and present evidence later before an immigration judge. On the other side, the opposing attorneys argued before the justices that allowing the government to parole a green card holder first and then justify that decision afterward opens the door to a potentially significant expansion of government authority. The concern raised was that such a power, once established, could be applied broadly and might create real risks for lawful permanent residents across the board. Immigration advocates have expressed concern that if the government's position prevails, all lawful permanent residents might need to consider the possibility of parole or even detention when deciding whether they can safely travel internationally for work, family obligations, or any other reason. Think about what that could mean in everyday life. Consider the green card holder who needs to attend a parent's funeral abroad. Think about the business owner who must travel internationally for a contract. Consider the elderly grandparent who wants to visit a sick relative overseas. Under the current legal framework, those individuals return home and are admitted. Under the framework the government is asking the Supreme Court to endorse, those same individuals could potentially be paroled into the country based on a pending criminal charge, one that has not been proven, one that may ultimately be dismissed, and then face removal proceedings on a far more difficult legal track. The justices themselves appeared deeply engaged with these concerns during oral arguments. One justice raised the concern that a motivated administration could use expanded parole authority to inappropriately place people in legal limbo rather than admitting them, effectively restricting immigration through administrative tools rather than formal policy changes. Other justices pressed both sides on where exactly the line should be drawn and what evidentiary standard border officers should realistically be expected to meet. Based on the oral arguments, legal observers have noted it is possible the court could divide along ideological lines, with a decision expected by early July. That means this is a developing story, and we will be bringing you the ruling and a full analysis the moment it comes down. So if you have not already subscribed to US Updates Hub, now is a good time to do so. It is also worth understanding this case within the broader legal context of immigration decisions coming from the Supreme Court this term, because this case is not operating in isolation. Earlier in this term, the Supreme Court decided a separate case involving the standard courts must use when reviewing asylum determinations made by immigration judges. In that ruling, the court addressed whether courts of appeals must apply a particular standard of review to Board of Immigration Appeals determinations in asylum cases involving persecution claims. That decision tightened the standard for how federal courts can intervene and re-examine immigration judge decisions, which has implications for thousands of pending asylum cases across the country. And separately, the Supreme Court has also been actively involved in disputes over the temporary protected status program. As of early 2025, a significant number of people from multiple countries were living and working in the United States under TPS protections. The court has weighed in on the administration's authority to revoke those protections through multiple emergency orders, and final rulings on TPS for certain nationalities are still pending. What all of this tells us, and this is the broader message we want you to take away, is that the immigration legal landscape in America right now is in an active period of meaningful change. These are not abstract policy debates. These are real legal decisions made by 9 justices that determine what happens to real families, real workers, and real human beings who have built their lives in this country. And being informed is not just helpful right now, it is essential. So let us talk about what you should actually do with all of this information, because we never want to leave you with news that feels concerning without also giving you something practical and actionable. First and foremost, if you are a lawful permanent resident and you are considering international travel in the coming months, please make sure you consult with a qualified immigration attorney before you go. This is especially important if you have any pending legal matters, any prior arrests, or any criminal record, even for something minor. even for something that occurred years ago. The case before the Supreme Court is specifically about what can happen to green card holders with pending criminal matters when they return from abroad. Do not assume your situation is outside the risk zone without professional guidance. Second, gather and organize your documents. Your green card, officially known as Form I-1, should be current and not expired. If your green card is expiring within the next year, begin the renewal process now by filing the appropriate form with USCIS. You can find all official renewal instructions at uscis.gov, which is always your most reliable source for forms and filing information. Keep copies of your green card, any re-entry permits if you travel for extended periods, and documentation of your ties to the United States, including your lease or mortgage, your employment records, and your tax filings. These documents do not just protect you at the border, they tell the story of who you are and how deeply rooted you are in this country. Third, if you have any prior criminal matter, even one that was resolved years ago, even one that was expunged, please speak with an immigration attorney specifically, not just a criminal defense attorney. Immigration law and criminal law interact in ways that are not always intuitive, and what might seem like a fully resolved issue in criminal court can still carry immigration consequences that a non-immigration attorney might not identify for you. Many nonprofit legal organizations offer free or low-cost immigration consultations, and USCIS maintains a list of accredited representatives and recognized organizations at uscis.gov. Fourth, stay informed. Continue checking back with us here at US Updates Hub, where we track Supreme Court decisions, USCIS policy updates, DHS guidance, and other official developments on a regular basis. The moment there is a ruling in this case, which is expected by early July, we will have a full breakdown of exactly what it means and what steps green card holders should consider taking. Immigration policy can and does change, sometimes quickly, and being ahead of the information rather than behind it can make a meaningful difference in your life and your family's life. Let us also speak briefly to those of you watching who are on different immigration pathways, perhaps applying for a green card for the first time, or sponsoring a family member. The broader legal environment matters for you as well. Evidence standards for immigration proceedings have been evolving, and immigration judges have been granted greater discretion in certain cases, making it more important than ever for applicants to work with knowledgeable attorneys who understand these changing standards. This applies whether you are going through an employment-based process, a family petition, or an adjustment of status from within the United States. Make sure your applications are complete, accurate, and thoroughly documented. One of the most consistent patterns seen in immigration denials or delays is incomplete documentation. And in an environment where scrutiny may be heightened, thoroughness is your strongest ally. And to those of you who are newer to this journey, perhaps just beginning to understand what a green card is and what it takes to obtain one, please know that while the news cycle can feel overwhelming at times, the path to lawful permanent residency is still very much open to those who qualify. The system has established processes, and those processes, while imperfect, are navigable with the right support and the right information. That is exactly why US Updates Hub exists, to translate the complexity of immigration law and policy into clear, honest, and accessible language so that you can make informed decisions about your future and your family's future. Before we close today's video, here are a few important reminders. The information shared in this video is current as of early May 2026 and is based on official sources including Supreme Court records, USCIS guidance, and established legal reporting outlets. Please remember that immigration policy can change, and what is accurate today may be affected by a court ruling, an executive action, or a legislative change in the future. That is not said to cause alarm. It is said to encourage you to stay engaged, stay informed, and consult a qualified immigration attorney for guidance specific to your individual situation. Nothing in this video constitutes legal advice, and no two immigration cases are exactly alike. Please do your own research and seek professional consultation for your specific circumstances. If you found this video valuable, please take a moment to hit that like button. It helps more people find this content when they need it most. Share this video with a friend, a family member, a coworker, anyone you know who holds a green card or is in the middle of an immigration process. They deserve to have this information too. And if you are not yet subscribed to US Updates Hub, please subscribe now and turn on notifications. Because as mentioned, the ruling in this major Supreme Court case is expected by early July, and we will be covering it the moment it is announced. You do not want to miss that. Check the description below this video for links to USCIS resources, official government guidance, and information about how to find accredited immigration legal help in your area. You are not alone in this journey. Millions of people across America are asking the same questions, facing the same uncertainties, and trying to navigate the same system. And you deserve accurate, trustworthy information every step of the way. This channel is here for you. Thank you for watching US Updates Hub. Stay informed, stay protected, and we will see you in the next video.